Good evening, everyone. I'm Jamie Parrott, Vice President and Chief Operating Officer of MedResults Network, and I'm delighted that you're joining us for this MedResults Network educational presentation. Over the 8 years that I've been with this organization and the 10 years that MedResults has been in business, I'd have to say that one of the most common problems we've seen in aesthetic practices occur around employee issues and human resources. And whether it's a practice who doesn't have an updated employee handbook, perhaps one that doesn't know what to do about a disruptive employee, or simply one that truly has no idea that their business policies are wrong, we've really seen it all at MedResults Network. And these are exactly the reasons why we chose to partner with today's special guest, Cedar HR Solutions. For those of you who don't know much about our new partner, Cedar, they're the industry leader for remote executive level HR support for all types of medical practices. And they provide several different services to the aesthetic medical community, including employee handbooks and HR support, as well as HIPAA training for employees and managers. And ultimately, they provide the tools that our members need to make the strongest HR choices in their practices, which is why we chose to partner with them. Today, we've invited Paul Edwards. He's the CEO and co-founder of Cedar HR Solutions. He's here to speak with us about one of the most problematic topics in an aesthetic medical practice, and that's the employee handbook. Paul has had years of experience, and he's probably seen just about every worst case scenario when it comes to handbooks. So I'm going to let him provide additional background about himself and Cedar, but I can assure you that you're definitely going to be walking away from today's webinar knowing exactly what not to do when it comes to your own handbooks. So with that said, we do have a long presentation, so keep in mind, if you have questions during today's webinar, you can use the chat feature, or I believe it's called questions, to type those questions into Paul. Also, a 5-question survey will pop up automatically following the close of this event so that you can provide some valuable feedback to us about the presentation. This survey, it'll also give you an opportunity to ask questions of Paul or to receive information from Cedar directly. So please take a few seconds to fill this out for us. It'll also provide us information that will help us design future presentations around the topics that you all want. So without further ado, I'd like to introduce you to Paul Edwards, CEO and co-founder of Cedar HR Solutions.
Jamie, thanks for that introduction, and I want to welcome everybody to today's webinar titled The Worst Handbook Ever Written. And of course, the question I'm asking all of you out there is it yours? One of the things I hope that you all take away from here today in the presentation is you should be able to look in your employee handbooks at the end of this and see a few things that might be problematic and know what to do with them. On the other side of that, you know, as Jamie said, we've been doing this for a long time. We established the organization in 2006, and I think there's a lot of confusion around HR, and I think a lot of that confusion is created by payroll companies where they say we're HR and they'll have some kind of HR service, when in fact they're focused on payroll, and HR is kind of second nature to them. They are not really industry specific, and so we recognized that there was a big problem there. And we created Cedar in order to actually focus on the HR issues, and it's really it's been a great trip so far over this last 12 years. We've learned a lot, and as Jamie said, we've heard a lot. We've seen a lot of handbooks, and we take over 10,000 calls per year from our what we call members. They're our customers, and we take over 10,000 calls a year and help managers and owners solve those HR problems that are going on in their practice. And I'll talk a little bit about I'll talk a lot a bit about the role that your employee handbook plays in that. So as you saw, that's me. If there's a picture of me, that's great. We'll move on. I've already given you an overview of what we do. We're very specialized. We don't work with cat grooming companies. We don't work with carpet cleaning companies. We work within the healthcare field. We have several Medi-Spas that are already clients of ours that have looked to us for several years now to be their HR support system. So today we're going to discuss what handbooks are, what they do, what their purpose is. We're going to talk about these 5 policies that I have on the screen here. At-will employment. We're going to talk about the National Labor Relations Act, leave of absences, specifically around maternity leave. We're going to talk about harassment and discrimination and disciplinary procedures. These are all areas where you can get yourself in a little bit of trouble by creating a policy around it. A common sense policy is usually what I call them. You'll create a common sense policy around it, but then you'll end up actually causing yourself harm by putting something in writing in your employee handbook that could actually be illegal. And then interspersed within these, I'll give you some examples of discipline, pregnancy leave, and harassment policies that look great but aren't. And then I hope I have enough time at the end. I'm going to give you a little bonus conversation about wage and hour, and I'll give you some self-assessment tools for that. So employee handbooks. An employee handbook is a compilation of your policies. You do create some agreements with your employees within your handbook policy. One of them, for example, and I keep it very, very simple, we open at 9 o'clock, 9 a.m. So there's an agreement. We'll be here, you'll be here, we're going to open at 9 o'clock. It also addresses expectations that you have for your employees about, creating, speaking professionally, protecting HIPAA information, protected health information, those sorts of things. Now, in parentheses, I said without actually creating an agreement or a contract. And I'll touch on that a little bit further into the presentation, but you can quickly turn an employee handbook, a set of policies, into a contract. And that's not something that you want to do. You want to maintain your at-will status because, well, that's just what you want to do as an employer. So types of handbooks that we see out there, templates from the internet, you guys have seen them. Those provided by payroll companies, they're generally designed to be generic enough to work for your business and to also work for the cat grooming business next door. We don't think that's a great model. We have those that are created by law firms. The problem with that is that the law firms have little or no specific knowledge about your industry or your business needs. So in both of these previous instances, the payroll companies and the law firm, we've seen handbooks be delivered that are really good at certain things, but they'll miss something, like they won't even address protected health information within the policy itself, or they won't talk about Hep B, or any of the things that are specific to the industries that we work in. And then there's that model that you would know that we like the most, and that's those that are crafted for your business and they're done with you. They have to include training. When we do a handbook for you, it complies with federal, state, and local law, and it's a powerful tool. And it's kind of like handing you without training, it's kind of like handing you a helicopter and not telling you, teaching you how to fly it and make sure that you have a full understanding of what the thing is that you have in your hands. And then the last thing is that you always need practical HR expert guidance to support a good employee handbook. And without exception, all books need to be kept up to date. Federal and state laws change. Depending on which state you're in, they can change quite a bit. So a good handbook, it's clearly written. It's been written by an employment law professional. It should be a barrier to both frivolous and valid claims or lawsuits. So a frivolous one is where someone claims you did something and you didn't, and you're able to, through policy, to actually be able to ward off an attorney who's kind of being a predator. And an example of that in not so much policy, but if you have a policy that requires all employees to report a problem, a specific kind of problem, say about paychecks, and you have an accusation against you that you're not paying someone properly, and in a deposition, they're asked, when did you discover this? And they say a year ago. The next question is why didn't you tell someone? You have a policy that you signed and acknowledged. It's kind of weird that you knew this was going on, but you never told anyone about it. Now, why this is important is because sometimes you will make a mistake. So let's talk about a valid claim. Maybe you were not paying them properly, or you'd misclassified it. Maybe you did make a mistake, or maybe a manager was doing something they shouldn't do, adjusting people's time. What you want to be able to do is just correct the error. You don't want to get hit with all the additional penalties and stuff along those lines. So very important that you have those kinds of policies correct. It should be recently updated for you, and it should reflect that it's been crafted for compliance, as I said before, with state, federal, and local municipal laws. Finally, and again in parentheses, it should act as a guide. If you go to follow a policy, better yet, think of the next person behind you. A new manager comes in and they read the policy that's there and they follow it. They should have pretty much blind faith that that policy complies with all of the laws. It shouldn't have to be reinterpreted by them. And you know, when we say local municipal, that's new for us. That started happening 4 or 5 years ago. Good examples are that a lot of local municipalities are passing mandatory paid sick leave rules. For example, in San Francisco, theirs is more strict than the state. So you would want to make sure if you were in San Francisco that you followed it. And by the way, if you were just outside the edge of San Francisco, you want to make sure you don't put that policy in your employee handbook. They need to be easy to understand, well written, thorough. They need to have up-to-date language in them. Employees shouldn't feel threatened by the language that's in them. And as I have stated, maybe overstated, they should have some support with them. A bad handbook, those top 3 handbooks I described to you earlier, the one that's made for everybody, the one that's a template that requires you to make changes to it when you aren't really an HR expert. You know, the ones created that don't take into account your business, handbooks that aren't updated, handbooks that were created by a non-professional or are being changed by someone who doesn't have very, very specific HR law experience, HR regulation understandings. And then finally, the worst handbook is a handbook of policies that's missing something. There are many policies that can protect you, but if they're not there, they can't protect you. And then just beyond that are ones that are not legal. You, in your own words, you put something in your handbook that is not legal, and there's no defense around that if you end up in a tussle with an employee. Purposes of an employee handbook, it's twofold. One, I've kind of touched on that. It helps you run your office. The other one is it's litigation avoidance, and I think I've made my case for that so far. So let's move into the 5 areas that we said we were going to talk about. They're very easy to get wrong, and so I want to start with at-will employment. And you know, only you can destroy your at-will employment status. Seriously, as an employee comes in your office to work for you, they're an at-will employee. What at-will means is that you or the employee may end the relationship at any time for any reason, with or without notice, and you don't have to give a reason, neither one of you do. Now, the employee is really free to follow that model. They can not come in one day, they can walk out one day and not tell you why, they can give you no notice whatsoever. That's at-will employment. The employer can do that to a degree, but at-will is not a bulletproof shield, because the issue here is there are multiple reasons why you cannot terminate an employee. And so, for example, and I'll go to the extreme, but it'll make my point. If you have a pregnant employee and you fire her and you don't give her a reason, then what she can do is go to an attorney. They will say that you fired her because she was pregnant. And then, of course, you will not have given her a reason, so you don't have a supportable reason, that maybe the real reason why you let her go. And the overriding factor is that she's in a protected class. Now, no one listening here would fire a pregnant employee. But I could insert many other examples. Let me insert another one for you. In the state of Arizona, if you fire an employee within 3 months of them having taken a paid sick leave, a mandatory paid sick leave day, which they have earned, if you fire them and you don't give them a reason or you don't have a documented reason, it is presumed in the regulation that you are retaliating against them for exercising their right to take that paid sick day. So that probably is beginning to not sound like at-will employment anymore. So keep in mind, I want you to maintain your at-will status, but it is not a bulletproof shield. You have to have structures in place for documenting what's going on with employees. At-will disclaimers, so here's something you can use in your book to just take a look. You do want to include that nothing in this handbook creates any right of continued employment. Now, there's another policy I see out there that says this is not a legal document, and it's used as a disclaimer. Well, that's not true. It is a legal document, and the fact that you want to be able to say to someone, you acknowledge that you would tell me that you were being harassed, and not just and let me know so I could do something about it. You want them to be bound by that. So you don't want to put in there that it's not a legal document. That's not a great thing to have. The other thing that you want to make sure that you include is no contract is formed by this employee handbook. And that is the power of a good and well-written policy. It just actually lets everybody know that this is not a contract. We are maintaining our at-will status. Avoid 30-day notice of resignation being required. You are required to give 30 days notice. Does not qualify as at-will employment. It implies that if you don't give me 30 days, I might not pay out earned vacation time when I don't have to by statute, or I might not give you a good recommendation, and that is not at will. Another one is these are our agreements, or the words you agree to. I see that a lot at the top of the page. It's a replacement for core values, and you say these are our agreements, and you say things like we speak to our patients respectfully, we show up to work on time, we have a good attitude, and you'll have a list of your core values, and you'll have them as agreements. Well, what you've done is you've opened the door for an argument to be made that the employee met the agreements, and therefore contractually you can't let them go for some innocuous reason, like you're just not a fit anymore because they met the agreements. Again, this is usually coupled with some other protected class complaint and then kind of used against you. All right, so let's move on to the National Labor Relations Act. The National Labor Relations Act was formed, I think, it was in the early 30s. It was basically to protect employees who wanted to unionize. What the act says is that you can't have language, you cannot have a practice which chills an employee's ability to discuss the following things: their wages and pay, their working conditions, or their benefits. You can throw safety in there as part of that as the working conditions. So what they're saying is employees have a right to discuss these things, because without being able to discuss them, they would not be able to organize as a union. Now, most people who are listening, if not all people who will listen to this broadcast, you'll say, well, I don't have a union. I don't have to worry about that. That's a union rule. Well, unfortunately, that's not true. There's a board that enforces this, and the board will enforce it whether you have one employee or 1,000 employees. And it does not apply just to unionized businesses. It applies to everyone. So we have seen them go in and enforce the act in a practice with only 15 employees in Texas. In fact, the state Texas Dental Board got sued by them for doing something they weren't supposed to do. They fired a couple of guys for talking about their wages, and so you just want to make sure that you don't run afoul of the National Labor Relations Act. And there's a lot of language out there, like no loitering, no gossiping, any policy that even vaguely addresses that employees can't discuss their wages, that they're confidential. Any of those things are they're not just bad policies. They're not just inaccurate policies. They're illegal and actionable, and there is no defense for it, because the National Labor Relations Board is the judge, juror, and executioner on this thing. And we've tussled with them a few times, and it's you just can't win against the government, against the feds. When you violate the NLRA, a lawsuit can happen. They come from aggressive plaintiffs' counsels who understand it, because what they get to do is take a two-pronged approach. They turn the policy over to the board, to the local board member. That board member files a complaint, comes after you, and then they get to come after you. The NLRA agents actually come to your office and talk to all your employees. You literally have to shut down for a couple of days. The cost of defense is ridiculous, and the list goes on. So you just want to be very careful. This is one of those things about, don't do it. Just avoid it. There are other ways of dealing with people who are kind of causing problems in their language and the way that they're acting out at work. You just don't want to focus on a gotcha, like, hey, you were gossiping, I'm going to let you go. Let's move to leave of absence. So the typical problems with leave of absences is they're not written, so the employee doesn't even know what to expect. And when you don't have a policy in place, then you also don't have an opportunity to create consistency. And I'll go back to that idea that everyone should be able to look at the policy and understand it, know that it follows the rules and the guidelines, and then you follow it for everyone. Which brings me to the next, which is a case-by-case basis. And I've had plenty of times a doctor say, well, Becky has been with me for years, and I'd love for her to have 10 weeks. This new girl has only been with me for a month. I didn't even know she was pregnant. Now she's letting me know. I don't really like her. I was going to let her go, but I just found out she's pregnant, so I thought I'd call you and talk about it. What I don't want to do is give her 6 weeks off to go have a baby and then come back, and that's just, you know, one example of what goes on. We see some language in leave of absence policies that has automatic termination language, which says that if you don't come back at the time that you agreed to, so if you stay out longer than the 6, 8, 10, 12 weeks, whatever it is that you choose to allow, then you're automatically terminated. And that's very, very, very bad idea. But there is a way to very clearly address what happens if they don't return on time. Or they're not, the policy is just not complete. There's not enough there. So we sent out a policy for everybody to look at and said, if this looks okay to you, then you probably should come and take this course, because this is not okay. So the employees who become pregnant may continue to work so long as it does not endanger your health or that of the child. That is a violation of Title VII. You do not get to make that decision. That is a very, very bad policy. It can be used against you. I know it makes sense, and that's what we want to have happen, but you as the employer or a manager do not get to make this determination. What you're basically saying is if I feel that you or the child may be, the unborn child may be in danger, I get to make the decision and take your livelihood away from you. To ensure safety for both mother and child, we ask that as soon as you become pregnant, you please notify the practice. When you do that, we're going to provide you with a fitness for duty certification form, and you and your doctor can fill that out, and you'll return it to us as soon as possible. That seems like a good idea too, but it's actually not legal. You don't get to make her go to her doctor to certify that she can continue to work for you. It's a misuse of the certification for duty form. That form is to be used to bring a person back off of a temporary disability or a temporary leave of absence, to say to the employee, now that you're ready to return to work, please go to your doctor, give them a list of all your duties, and let's make sure that it's okay for you to be on your feet all day, or okay for you to be sitting all day, or okay for you to work your full 8-hour shift. I need you to certify that you're ready to come back to work. So in this case, this is one of those policies where if I'm the EEOC, I just show it to the adjudicator and you lose. That's it. There's no way around this if you've been following this policy. All of these things about we comply with the ADA rules and all that stuff, and we're EEOC compliant and all that, that's fine. And then finally, we said under the FMLA, that's the Family Medical Leave Act, you're entitled up to 8 weeks of leave. And employees who fail to return to work on time may be subject to discipline up to and including termination. And you remember, I talked about that before. The policy has a couple of really bad pieces of content in it. The policy misapplies the use of the fitness and return to duty certification. It fails to address a procedure for noticing the employer of their intent to return to work or to ask for an extension. The extension is very, very important these days. The policy really fails to address 5 or 6 other things that you need to make sure that are in it. So in this case, it looks great, but it's not good. I'm just kind of looking at this policy. I think this is a really good point. We found this policy in California. There is a state-sponsored pregnancy disability insurance program there. That insurance program requires you as the employer to notice that employee that it exists and how they can take advantage of it. And of course, they missed putting that in. And then it referred to the Family Medical Leave Act, which they shouldn't have because they only had 8 employees, and that act applies to an office with 50 employees. So that was really a bad thing to put in there. Obviously something that was borrowed. I think in this case they had 22 employees. And the FMLA is actually 12 weeks, not 8 weeks. So they didn't get any of that stuff done properly. Another thing that we see or we hear is that a payroll company told you that you have less than 15 employees, therefore you don't need this policy. You're not required to give it by the feds and it shouldn't be there. That's actually not true. You're in a business that's run primarily by women. You're going to have people who are going to get pregnant, and you need to have a good, clear policy and treat everybody exactly the same. So that's just really, really important. You want to make sure that you include potential length of leave, the option to extend, the types of leave that are available, properly use the doctor certification, reinstatement rights, what happens during this time when it comes to earning PTO, because you'll have benefits running at that time, so you need to address that. You need to talk about insurance during this time, and you have some choices you can make around that. We talked about fitness for duty, and you always want to consider accommodations. You may get a note from the doctor on the certification that says she can return to limited duty for 3 weeks, and then she should be able to go to full-time duty after that. You want to make sure that you consider the accommodation, and in most cases, you follow the accommodation. Let's move on to harassment and discrimination. Here's some numbers for you guys on the screen. You can see the numbers. There's a lot of discrimination charges. They occurred in 2015. We're waiting that the government runs about a year and a half behind. We're about to update these to 2016. The truth here, though, is that the average time that it takes to deal with this is a year, and when you consider settlement costs and everything else, it's easy to spend $125,000 fighting one of these lawsuits. Here is an example of a harassment policy. Your employer is committed to providing a work environment that is free of discrimination, and everybody else can read as we look through this. Because the real problems with this policy lie in what's not in it. So there's nothing in it that's terrible, in and of itself that we see here. What's wrong with this is what's missing. And so let's move over to the analysis. While the policy appears to cover unlawful workplace harassment, it actually covers only sexual harassment, and there are 4 other types of harassment which can be addressed in your employee handbook. And when we say can be, what we're saying is the EEOC has identified them, and they've said that, look, if you address these, if you define these, if you promise the employee that you will not retaliate for reporting them, you show them a clear reporting procedure, you will have flipped the model on them. And what we will do is we will treat their accusation as something they have to prove, not as something that you must defend. So very important that if you get the policies in there, that you actually are on higher ground from the start if you get some sort of accusation. By the way, for those of you out there with multi-practices, you have more than one location or larger groups, a larger team. Sexual harassment typically happens in an outward way. It happens out of your sight. It's a manager somewhere. It's someone who's in charge of another one of your locations, and so that's what you're protecting against. Because around you, you're going to hear it. You're going to know that it's going on. But when it's not around you and you've got a larger team or multiple locations, that's when these policies can be even greater advantage. But they're great for everyone. So how do you prevent discrimination and harassment claims? You make sure that you have all of the policies. You make sure that you have the anti-retaliation policy. It's actually super important, and we find it missing a lot. It needs to be properly written. Again, people, the complaint comes in, you discriminated or you harassed, and then once you were told that, within some period of time after that, you started treating this employee differently. You may have fired them even though it wasn't for the reason that they're stating. So again, you want to flip the model, and we call it shifting the burden over to the other side. Make sure that you have your EEOC statement in it, good procedures, open door to multiple managers. And we say multiple managers because what if my manager is the one who's harassing me? I need to be able to go to someone else. So it's a good idea to have multiple channels for them to go to. You want to include third-party actions in one of the harassment claims. They can be harassed by a customer or a client or a patient. And so you want to make sure that that's one of the policies in your book. Look, the final word on harassment is, look, if quid pro quo versus hostile work environment, you want to make sure that you kind of explain these two things in your policy and make sure the employee understands that this is not okay and they need to report it to you. Always provide a good resolution process, which is to say, bring the problem to us, and this is how we're gonna work on it. And again, back to making sure that you define the harassments. Let's look at disciplinary procedure. Look, the typical progressive discipline policy, and a lot of people have kind of changed this and made it kind of weird, is you give a person a verbal, you give them a written, you might suspend them, and then you can terminate. we put steps next to this, step 1, 2, 3, and 4, and that's a big mistake. You never want to have a policy that steps through these things. Like if you're late the first time, we'll do this, and then if you're late the second time, we'll do this, or you might create a bucket of things that they do. These are all really, really not good ideas. So here's a good example of a policy that we found. So they're going to measure lateness over a consecutive 12-month period. By the way, this disciplinary policy is just limited to lateness. So, but just because they limited it to that doesn't mean that now it isn't for all disciplinary policies. So, if someone breaks a HIPAA policy, we got to start over, or we got to start this bucket over for that as well. If someone I mean, we've always joked, if someone strangles a patient in the front room, do we start over with them at step 1 and give them a verbal? And the answer is no. So all of these things, these step-throughs, that might be the way you want to do it in the back of your head, but you should never tie yourself to this policy. And all suspensions and termination must be reviewed and approved by management, by the management team prior to implementation. We don't typically in businesses in the United States the size that we work with, we don't rule by committee. There's generally managers, and look, there can always be a review. The manager sees there's a problem, wants to let someone go. She's got to go to the administrator, the clinic administrator, or maybe to one of the doctor owners or something and go over it. That's fine. But what we don't want to do is say that everything will be reviewed by management, because if we get a complaint that comes in, they're going to want to see how you followed this policy, and they're really going to pick at it. And again, they can couple it with other complaints. So our question is, why tie your hands? I mean, it's the most difficult job you have, and you have little things that happen every single day, and every now and then you have big things. You just don't want to have your hands tied whatsoever. The other thing is that you want to make sure that you are documenting things properly. You don't want to take a lackadaisical approach to management. If you don't do a good job of documenting these things and talking to employees, and you use this format, this is the issue, this is the impact, and this is the correction that I'm looking for, and you document that with the employee. If you've got that in place and you get a lawsuit, even if you've done something kind of weird, or they make a case that you really can't get around and you decide to settle, it will settle for a fraction of what it would if you have not good documentation in place. So progressive corrective coaching is a term we coined in 2006 when we formed this company, because I did not like the word discipline, and I never have liked the word discipline. You want to have a flexible structure for managing your employees. You want to reserve the right to combine or skip steps. You want to emphasize the employee has a responsibility to make the correction. Look, as simple as, look, I know you're doing really, really well here. You've only been here 6 weeks. We're all impressed with you, but I don't know if you realize or not, you've already been late 3 times. And look, in the position that we hired you for, and we were really clear, you have to be the first one here to take the phones off the messaging, start picking up the messaging. And when you're late, the impact is that other people have to do your job. When they're not doing when they're doing your job, they're not doing their job. And you being late can actually cause us to run behind as we're seeing patients through the day. Next thing you know, it's all kind of snowballed. So what we need you to do is just recommit to being here on time every morning. That is I'm making it clear that they have to show up on time. You also want to give them an opportunity to respond to you, and you never want to tie your hands. I mean, I gave you some pretty innocuous examples, but someone posted on Facebook that some famous person was in the practice, was in your Medi-Spa yesterday, and it's amazing. I can't believe that person was here, and they name him. You're probably going to want to terminate him. You're not going to want to have to go through any steps. So the most important thing about progressive corrective coaching is how it's delivered. And we always ask, what if you could actually encourage the individual to self-correct and incentivize their improvement? And incentivizing improvement is to just recognize that the thing they were having trouble with, they're no longer having trouble with it. They're making effort to improve or have improved, rather than trying to degrade the person and like in a demotivating effort, you know, you just don't seem like you're going to get this, or you just don't, you seem like you don't care, or I'm questioning whether or not you're smart enough to interact with our patients the way that we need you to. Those are the sort of demoralizing statements that just aren't helpful, and they're personalized, and they don't help at all. But if you talk about the needs of the position, and you talk about what's required of the human being that's going to fill the position, using words like being on time, using words like, you know, you can say to people, just your tone, just your language, the things that you're using, and you're giving them examples of what they're using and what would be better to use. So you always want to empower an individual to make an improvement, but at the same time, you're documenting, and in many cases, you're writing some kind of a corrective action where they're acknowledging that we've had this conversation and they are going to try and do better at whatever it is. So now I'm going to move into the bonus section, and in the bonus section that we talked about, I wanted to talk about wage and hour classification for employees. This is an area where a lot of practices are getting this wrong. When you classify an employee, the first one that we see that they get wrong is independent contractor, okay? So for you guys, I'm saying that a lot of you, when you've come through the door in the past with us, you've made massage therapists independent contractors, or you've made your RNs an independent contractor. And the problem with that is that federal law and in a lot of states do not allow you to do that. So I want to define what an employee is and what your role is in classifying them properly. So when someone walks up to your door to start work for you, you have a responsibility to make a determination as the employer of whether or not they are an employee or they are not an employee, say an independent contractor. And an employee is someone who works for you doing the work of your business. That's me simplifying it. And I'm going to send you guys after this presentation, I'm going to give you a lot more information on this so that you can actually self-analyze your independent contractors to see if there really are independent contractors. There's a misnomer out there that if someone works for other people, that could make them an independent contractor. That has a modicum of truth to it. A person who is an independent contractor is allowed to work for other people. So one of the ways you can make someone not an independent contractor is they only work for you. So let's start there. But then the argument's made, well, they work for 2 or 3 other practices, and therefore that makes them an independent contractor, and that's just not true. You know that's true. You know that's not true because you know that just because your receptionist who answers the phone works for another business or another business as a receptionist, you know somehow that person is not an independent contractor. Now, the reason why people like to make people independent contractors, I'm not exactly sure why it's a good thing. It's usually driven by accountants, not CPAs, but accountants. A CPA, a certified public accountant, or an attorney will not tell you that it's okay to classify one of these people as an independent contractor. An accountant might, because they say that there's some kind of tax advantage there. They'll say that you don't have to pay Social Security, you don't have to pay these other things, and therefore you'll save some money. That might be true, that you might save some money, but what you're also doing is you're violating labor law, meaning that you are not withholding their taxes and paying it out to the government. You're not paying the matching taxes that you're required to pay. You're not withholding their Social Security and paying it in the Social Security system. Now, how this makes you vulnerable is it makes you vulnerable in a lot of ways. First thing is they're not subject to your employee handbook. Now, the problem here is that they're actually employees. You've misclassified them as an independent contractor. By the way, you cannot give an independent contractor your employee handbook because then you would be saying, wait, you're 2 different things. So you lose all of the protections in the employee handbook, yet all of the laws that apply to them, that apply to an employee, still apply to that person that you've misclassified. Another problem that you have is that if you have agreements, and we do injector agreements and RN agreements and stuff like that, and where it's appropriate and where it can be enforced, sometimes we put in non-competes and non-solicitations and other protections inside of an at-will employment agreement. So it's a subject we won't go too deep into. When you classify someone as an independent contractor, you cannot have a non-compete with them. Now, you can make them keep your information private and not steal patient information. You can do all those things. But you lose a lot of things when you put someone as an independent contractor. Something else that you lose is your workman's comp coverage. So I don't know how many of you out there, many spas don't do a lot with insurance, but you have health savings accounts and stuff like that that take advantage of you. But I would tell you that you want to take into consideration that if they get a Hep C stick, that your workman's comp's not going to cover it, and the practice is going to pay $65,000 for those little pills that they have to take, and you're going to have to take care of that person possibly for the rest of their life, because your workman's comp is an insurance company. We all know how insurance companies make their money. They make their money by not paying claims. That's the model. So I'd be darned if I want someone to come through my door, I'm going to misclassify them. I'm going to save $10,000 on taxes, but I'm at risk that they could sue me under all the rules that apply to them. In California, for God's sake, you could not end up giving them their breaks like you're supposed to. That can add up to hundreds of thousands of dollars for an independent contractor. So you want to make sure that you get this right. The other thing that I wanted to look at is the exempt versus non-exempt salary basis. A lot of people are, RNs are an example. Generally, massage therapists are not a great example of this. Office managers of small practices are a great example of this, where you put them on a fixed salary, exempt, don't pay them overtime. That is a real classification. There are lots of people who can fit into it, but RNs are not one of them. Office managers can. If you spend more than 50% of your time managing 2 or more people and a few other conditions exist, you can be put on a fixed salary basis. So there's salary exempt from overtime, and there's I pay you a fixed salary, but I still require by law to track your hours, and if you work more than 40 hours, I have to pay you for overtime when that occurs. If you're watching a rebroadcast of this, and so everybody who's listening, I need to address that for a second, because we'll put this up as a rebroadcast. You can still send your questions to me at paul@cedarsolutions.com. Our capacity to answer these questions is pretty good. We'll get very specific with you. You could even get on the phone with us and say, hey, can you just really go through this with me, and we can kind of help you go through it and have a good understanding. Again, you could just send an email to me at paul@cedarsolutions.com. I do have a team of about 12 people who have law degrees, who are HR experts, who answer all those calls that come in. I may get them to jump in and help us so that we can get you a reply in a quick way. But I just want to let everybody know that whether or not you're attending this live now or you're watching it afterwards, feel free to shoot your question over to me. Part of being in the MRN network and us being in that network is that we extend to all the members of that network at least one, what we call a get out of jail free card. Meaning that you have a problem, you have an issue, you've heard something in this broadcast, or you just have something come up in the near future. If you shoot an email to me and you put the words, if you put MRN in the subject line, we'll know that it's coming out of the network, and we'll get back to you, and we'll do everything that we can to help you. We plan on sending you a full analysis. So if you signed up for this, we've got your email, and we're going to follow up with you and send you 2 or 3 emails afterwards. Also, we have a website here, cedarsolutions.com/MRN. You can jump in to request that analysis of your employee handbook as well. So let's just jump into that. A couple things you can get. Complimentary newsletter from us. We put out a newsletter about every 2 to 3 weeks. We're just going to go ahead and start sending you copies of that. If you don't want to read it, you can opt out of it. But I think you're going to find it pretty fascinating, because we draw off the actual problems that come in. Of course, we kind of scrub them. Nobody knows, the identity of anybody who sent it in, but we share how we solve problems. We'll often share updates about things that are changing in state and federal law. So the newsletter is something pretty cool to hang on to, and it goes out to over 23,000 people now. So it's kind of really well received. An offer that I want to make to everybody who's here listening or listening to the rebroadcast. there's nothing better than context. If you've put your employee handbook together, or perhaps the owner of your business has put it together, or as most of us, we kind of cobble these things together, and as problems come up, we add policies. And as we go to seminars and conferences, or we listen to guys like me, we pick up a little tidbit here and a little tidbit there, and we make these changes. At some point, your handbook has probably taken a wrong turn. When I say context is great, it's like if you explain to me what's wrong and help me to understand what's going on, it's a lot easier for me to make the correction, and a lot easier for me to be a better manager when I get that kind of information. So if you want to, you can use my email address, or you can send it to eval@cedarsolutions.com. Send your handbook over. The first 40 MRN members who send theirs over will waive the fee. So just don't delay, send the book over. And what we're going to do is we literally are going to spend an hour. We've got a special person here, and we look at all your federal and state laws, and we look at your handbook, and we point out where it's good. We point out where it has maybe some illegal policies in it, and we'll point out the number of missing policies that aren't in the handbook. Then we get on the phone with you and we talk about it. We give you that context. We give you an opportunity to talk to us. And there's just no obligation for you to do anything else. You don't have to do business with us or do anything, but obviously it's an opportunity for us to interact and kind of, share what it is we do and see if maybe we might be a right fit for you. So that's it, guys. That's our presentation for today. Your employee handbook is probably one of the most important documents in your office. It needs to be perfect. It needs to be spot on. It needs to be kept up to date. It needs to be a helping tool for you. It needs to be a litigation avoidance tool for the practice itself. And with that, I'm going to just let you know that if you need anything, you can reach out to us at 866-414-6056. You can send an email to me personally at paul@cedarsolutions.com. We want to thank the MRN Network once again for inviting us. We plan on giving you guys lots more presentations, and look for our articles to start to show up on your front door here soon.
Perfect. Paul, thank you so much for preparing this presentation today, and I want to thank all of our attendees who are here live or who are going to be listening to the broadcast. Just keep in mind, if you have any questions, as Paul said, feel free to reach out to him directly. I know I've communicated with most of you directly prior to this, so feel free to connect with me as well. And just as a reminder, that automated survey is going to pop up as soon as we close down the presentation. That'll give you guys an opportunity to ask Paul any questions that you may have thought of during this presentation that maybe he didn't address. And we'll submit those over to Paul. He can get back to you ASAP. But once again, we just want to thank you. And Paul, we appreciate the content in the 4 years of us doing these presentations. I've certainly learned probably the most out of this presentation than I have in all of them. So thank you again, and we look forward to seeing everybody on our next MedResults Network educational presentation. Thank you, and have a great rest of your evening.